So partisan gerrymandering had been challenged for years, and that several times when the U.S. Supreme Court had faced the issue, the court basically had said, well, partisan gerrymandering, or at least some level of partisan gerrymandering, is unconstitutional, but we haven't figured out how we tell the difference between something that's perfectly fine and legal and something that goes too far. Because what the court said is anytime a legislature does anything, that's inherently partisan, right? And we kind of expect that. We expect when the legislature passes tax laws that it's going to be partisan in nature. And if you don't like the laws that the legislature passed, well, the solution is to vote the bums out. And so the court has struggled with this idea of if everything a legislature does is partisan, and the US Constitution gives state legislatures the authority to dictate the times, place, and manner of federal elections. So it gives state legislatures the authority to draw the maps. How do we tell when that action is their normal politics or is politics gone too far? Right? And the court had said we don't have a test that we like. Well, a bunch of different scholars, law professors, political scientists, mathematicians have all come up with tests to measure when a map is sort of among the normal range of what you might expect, even from a partisan body, and something that's a far, far outlier. And the North Carolina map, for example, was clearly a far, far outlier, and the map drawers didn't hide what they were doing. So in North Carolina, there was 14 congressional districts, and they drew a map that was 10-4. So 10 strong Republican districts and 4 Democratic districts. And when asked why, and the key Republican lawmaker who drew the map, when asked, why did you draw a map that was 10-4? He said, well, I couldn't figure out a way to make it 11-3 and still comply with the one person, one vote standard, right? So it was implicitly partisan in terms of what they were doing. And the U.S. Supreme Court basically said, that's fine. That we're not satisfied that there's any test that can tell us the difference between normal politics in what a state legislature does and politics that have gone too far. There's many problems with this. The first being this is letting the politicians choose their voters instead of the other way around. This is the foxes guarding the henhouse because, what's the one area where maybe we should trust state legislatures the least? It's about rules that help them stay in power or rules about their reelection, right? State legislators, their number one goal, you wish it were to serve the people well, but their number one goal is basically to win re-election and keep their job. And so what better way to do that than to draw the lines in such a way that it basically makes it impossible for the other side to win, especially when you have, the primaries becomes the only game in town, essentially. So in most districts in the country now, we know which side's going to win, Democrat or Republican. There are very few swing districts these days. Okay, so that's problematic in and of itself. But I think the problem has become supercharged in these cases involving race. Because not only did the U.S. Supreme Court say we're not going to police partisan gerrymandering, but now we're seeing states use politics as their defense to every other potential claim against their maps. And we're seeing the Supreme Court essentially still defer to the legislature when using politics as the defense. So that Alexander case from South Carolina, the argument was that the state drew the map to pack as many black voters in as few districts as possible, such they had a super majority in very few districts and white people could control the rest of the state, basically. And that was the claim. And so the claim was you thought about race too much. And the state was able to say, well, we also thought about politics. And there's a political reason for why we did this. And the U.S. Supreme Court basically said, okay, that defeats the plaintiff's claim. And I fear that's the similar type of standard is going to be set out in this Louisiana versus Calais case. So it's really the intertwining of the partisan gerrymandering cases with the consideration of race and the allowance of states using partisanship as that defense.
Yeah, if I can push on that a little bit as a con law, guy who thinks in the sky, the striking thing to me, tell me if this is right, is that you start off with a thing where they're saying complying with the Voting Rights Act is a compelling interest. And then they say, the court says, well, yes, but you're not forbidden. You're not forbidden to use partisan politics. But gradually it's now become something that's equal to the non-discrimination claim. That it's like,
It's not even equal anymore.
Yeah.
I would say that the partisan defense has subsumed the concern about equal representation, because the plaintiffs bring a claim, and if this is how Louisiana versus Cadillac goes, plaintiffs bring a claim saying, here's the map that you enacted, here's the percentage of minority individuals, here's why the map was drawn. And by the way, when making out a Section 2 claim, it's not enough for the plaintiffs to simply say only one of the 6 districts is majority black, and it should be 2 because we're 33% of the population. The plaintiffs have a much higher evidentiary burden than simply looking at the numbers. They have to propose a new map to demonstrate how minority individuals live geographically near each other, such that you could draw a new map that had more majority black districts. You also have to demonstrate that the minority individuals in your area tend to vote as a block, tend to vote in the same way, have the same interests. You also have to show that the white majority tends to also vote as a block to outweigh the minority. So there was a district in North Carolina that was challenged, and the court said, well, but white people are crossing over and voting for the black preferred candidate. So you can't make out a claim there. And then after you do all of that, you still have to demonstrate under, quote, the totality of the circumstances that minority individuals are worse off in the area, looking at geographic living patterns, looking at history of discrimination, the ways they're excluded. So you've got a pretty high evidentiary burden for the plaintiffs to do that. But even if the plaintiffs clear all of those hurdles, if the court adopts this test that partisanship can insulate it, then all of that would be negated by the state simply saying, we were seeking to achieve a partisan end, here's what it was. And at least in the racial gerrymandering constitutional claim, that defeats the argument that race is used too much, at least when it's the black people challenging the white majority legislature in terms of drawing the map that way, as in South Carolina. And that could insulate Section 2 challenges as well. So, the headline would be court guts Section 2 or cuts back on it, but not strike it down. But the practical effect would be that it would be extremely difficult to bring a Section 2 claim against a map if the state could justify it based on its partisanship and partisan argument.